Good morning, and thank you for joining us today. I'm Álvaro Santos, Professor of Law at Georgetown University and Faculty Director of CAROLA, the Center for the Advancement of the Rule of Law in the Americas. Welcome to the third Career Paths session of our full series, The Americas in Times of COVID-19. Our session today is on international and transnational labor law, and we have a wonderful lineup of speakers who I'll introduce in a moment. The goal of this session is to present you participants with different perspectives, ranging from government service to private sector, non-profit, academic, in a substantive field of the legal profession. And we would like aspiring lawyers and young lawyers to learn from successful experiences and also appreciate how exciting, varied, and sometimes non-linear law careers can be. On the topic of today, international and transnational labor law, we have seen increasing concerns about the rise of inequality and the need to better regulate markets, and particularly the practices of corporations, both domestically and also internationally. This with the objective of ensure workers' rights enforcement, whether it's wages or working conditions, health and safety, but also the ability to associate and bargain collectively. Again, both domestically and also with international mechanisms. We think this has become even more urgent and perhaps more visible during the times of COVID-19. And so today we have a wonderful group of speakers who will be able to broaden our lens to think about different ways in which law could help address the well-being of workers. And I'll very briefly introduce our speakers because they'll have a chance to tell us more about themselves as they answer our questions. So in terms of format, we're going to run this session as a conversational interview where I'll pose a question and then give each panelist a chance to respond. So I'll introduce them in the order in which they will answer questions. So first we have Charity Ryerson, who's founder of the Corporate Accountability Lab. Then we have Josh Kagan, who's Deputy Assistant U.S. Trade Representative for Labor at the Office of the U.S. Trade Representative. Next we have Colin Fenwick, who's the head of the Labor Law and Reform Unit at the International Labor Organization in Geneva. And finally, we have Rangel, who's Research Director of the Global Trade Watch and Public Citizen. I should say that three of them are graduates of Georgetown Law. Nobody's perfect, Colin. We're really, really delighted to also be able to showcase what our amazing graduates have gone on to do with their professional lives. And obviously very excited to have you come and grateful for you sharing your time with us. Okay, so we'll start with the first question, which is an opportunity for introductions, really. I want speakers to tell us what their current job is and what kind of work they're currently engaged in. So let's start with Charity.
Great, thanks, Alvaro. This is exciting to be here with you all. I always love to do things with Georgetown just to connect with other alums also. So as Alvaro mentioned, I'm the founder and executive director of Corporate Accountability Lab. We are a small nonprofit. We have 6 attorneys right now. We were really founded in the wake of the fall of the Alien Tort Statute. I don't know if folks are familiar with that, but it was a statute that a lot of folks used for international human rights cases, including labor cases in global supply chains. It's still kicking around what's left of it. There's a case coming up before the Supreme Court this term on it, but it pretty dramatically limited the number of tools available to human rights litigators, thinking about how we deal with extraterritorial harms committed by companies, and particularly those here in the US. So I founded Corporate Accountability Lab to start to diversify some of the tools that were available to litigators, to victims of human rights abuse, labor rights abuse. And so that's what we do. Our day-to-day looks like, we focus a lot on trade law, contract law, intellectual property law. So different areas of law that companies use that they need to use for their own benefit and they can't systematically undermine over time as repeat players in the system, unlike human rights law, which they did effectively undermine. And so we don't have much of that left. So looking at different areas of law on the books, how can we creatively repurpose those to make sure that victims do have access to remedy and that corporate abuse is deterred wherever it's found. So maybe to be a little bit more specific about some of the areas of focus or work that we're doing right now, we've been doing several like petitions under Section 307 to Customs and Border Protection. So those are, Section 307 prohibits the importation of forced labor produced goods. So we're seeing if we can leverage that. I can talk more about that later. I'll say it's a little complicated to leverage it effectively to improve respect for worker rights in global supply chains, but that's what we're trying to do with it. We also are working on supply chain contracting, thinking about how companies and their relationships with suppliers can embed language in there that would give workers or victims access to remedy directly. We've got a big project in Colombia looking at the transitional justice process, looking at how corporate actors or economic actors have been systematically excluded. So there's no jurisdiction over companies. So we're trying to think about how can, in post-conflict settings, either companies have jurisdiction within peace processes, or alternately, what parallel mechanisms could we use? Are there civil liability strategies or other ways that we could bring them in for restorative justice goals? So it's kind of a big picture sense of some of the things that we do. There's a lot more. I'll say that we're a design lab, so we use design thinking and design process. So we really try to create a structure that is ripe for innovation and creativity, which is directly counter to the way most law firms operate. So that includes things like work-life balance and having a community of trust within the office, but also with our colleagues. So just thinking a little bit differently about the way we operate within hierarchies and how those either deter or incentivize innovation. So that's sort of part of our fabric as well. So that's what we do. I'll pass it on to the next.
Thanks so much, Charity. Let me now move on to Josh.
Thank you very much, Alvaro. Thank you very much to everyone at CAROLA. I appreciate the opportunity to join this great panel. I've been asked to note at the beginning that I'm speaking in my personal capacity, not on behalf of USTR or the US government. So as Alvaro mentioned, I'm Josh Kagan. I'm Deputy Assistant US Trade Representative for Labor in the Office of Labor Affairs at USTR, the Office of the U.S. Trade Representative. So we're part of the executive branch of the government. We're actually part of the executive office of the president, but I'm career staff. I've kind of made my way through the government over the last, depending what you count, 10 to 12 years. So I'm not a political appointee, but USTR, along with some other small components, are part of EOP, the Executive Office of the President. So my work focuses on the nexus between labor issues, labor rights, and trade specifically. So I focus on the United States-Mexico-Canada agreement, as we call it here, USMCA, the new NAFTA. There's a number of novel labor components to that we could get into a little bit later, I suppose, if that's where the conversation goes. I also focus on Asia and Africa and our trade engagement, labor-related trade engagement in those countries. And then I think somewhat germane to what Charity just mentioned, I cover forced labor and trafficking issues for USTR writ large globally. So that does include Section 307, USTR's involvement anyway in Section 307 of the Tariff Act. We have a number of trade programs, free trade agreements, trade preference programs, bilateral engagement, a number of forums that our office represents the U.S. government in. And the way I think about it is it's actually quite similar to what Charity just said about the need to use certain programs or certain provisions or certain laws for benefit. There's a lot of interest by many countries and by large corporations in trade law. So my view is that creates an opportunity for getting people at the table, getting their attention, and then talking about things like fundamental labor standards that are part of our U.S. trade programs, and doing it in a context where there's often people around the table who can make things happen. So that's very, very short overview. Thanks again, Alvaro, and I'll turn it over to Colin next, I think.
Thanks, Josh. Colin, you're next. I believe you're on mute.
Right, better? Sorry about that. I feel like my bounden duty to claim my heritage as a native-born citizen of Washington, D.C. And to my undying shame, I passed up on Georgetown for another law school, but things have worked out okay. Look, I work in this thing called the Labour Law and Reform Unit in Geneva at the headquarters of the International Labour Organization. So we serve predominantly the member states of the organisation on request from governments. In the unit, we do a combination of technical work in support of developments and progress in individual countries, and we also do research on sort of issues of global significance as we see them. So the countries in which we've worked over the last few months, I was just making a note of this, we've done some pretty major work for Mongolia recently, also Eswatini, Ecuador, Costa Rica, Vietnam, and Indonesia, some smaller things for Malaysia. So that work to which I refer takes the form of producing a sort of formal written analysis of draft legislation on request from a government, which we then transmit to them in the hope that they will take some of our advice. Now, I should offer the same disclaimer that Josh offered. I'm not speaking on behalf of the ILO, but when it comes to Indonesia, for example, recently they did adopt legislation which included a bunch of reforms which were not consistent with the advice that we gave them. So now we've got a very large political headache on our hands within the office. India has gone down the same road as well. So we've got some major challenges which are happening, and that's, I mean, that can happen at any time, but it's particularly because of the COVID context, right? So governments in some countries are doing things to try and stimulate their economy, which includes having some detrimental effects on workers in the interests of trying to get things going in terms of job creation. In terms of country level work and connecting to what Josh was saying about trade deals, we've also been involved in recent times in the unit in bids for money from the US Department of Labor. So one from Armenia, one from, we're desperately trying to finish one on time for Kenya at the moment, which is in anticipation of a possible trade deal there. Josh seems to be nodding his head as the Africa guy there. And then there's a bunch of money coming from USDOL because of the USMCA. So there's a number of projects which are being run by or bid for by the International Labour Office. And the team in which I work has got some connection to some of those, but not to all of them, because it depends a bit upon what type of work needs to be done. And then in terms of the kind of research stuff we do, well, in a sense, the International Labour Organization, everything is labour law, right? But we don't do the whole spectrum of stuff. We have particular interest in labour dispute resolution systems. So we're doing work on alternative dispute resolution systems, particularly for individual labour disputes. There is a possibility in the future that the office and the organisation will move to adopt a new standard on the topic around access to justice, if I get the chance to frame it the way I'd like. We're also doing work on labour courts at the moment. We have a particular interest in the contract of employment and how it's regulated in different countries in legal systems, how courts and legislatures respond to the challenges of changing labour markets. And at the other end of that spectrum, we have a database on termination of employment laws, which has recently been updated and which needs to come and see the light of day in some publications. We've also done some related work on the application of labour law to small and medium enterprises and the regulation of temporary agency work. And I think that's probably enough for now from me.
Thanks, Colin. And let me now pass the mic to Daniel.
Thank you, Alvaro. Well, I'm pleased to share my short experience on the field of international labor law. I have to recognize that I blush just by the idea of saying that I have a career in this field, but it's true that I have been working on that lately. And as Alvaro mentioned, careers in international law can be very non-linear, and I think that this is my case right now. I recently joined Public Citizens Global Trade Watch as research director, and I also have to say that the views that I'm presenting are my own. Well, here I am in charge of planning and executing research strategies and projects, mainly related to international trade, but also investment law, generally globalization issues. And this involves lately work related to the economic impact of trade agreements that have been ratified by the US. This is on the macro level, but also specifically on the communities inside the country. We have also checked the policy tools related to increase the resilience of supply chains of critical goods, which is very important now in the context of the COVID-19 crisis. Some work on investment arbitration, and specifically concerning the topic of this panel, with the ratification of USMCA, we have devoted a lot of our time on assessing the labor conditions and labor reform in Mexico. So basically, we are looking at how the new institutions that are mandated by the law that was passed last year, and they are also enshrined in the constitutional reform of 2017, how they are being implemented in different states of Mexico. We're also assessing and trying to understand all the struggles of independent unions in the country and the conditions of the workers in Mexico. Basically, our idea here is to put the spotlight on the issues and try to raise awareness of the challenges of the labor reform and the labor conditions on Mexico on this side of the border.
Wonderful, thank you, Daniel. So I think you can appreciate the range of issues in which our speakers are currently working, but also the different lens or angle from which they come at this work, even though there's a common interest here in the well-being of workers, and also the different kinds of legal strategies that they're pursuing. And so with that, let me turn to the second question, which is asking our speakers in their perspective, what are some of the most exciting challenges or changes in the field of transnational labor law, broadly defined, that you'd like to highlight? This would be also of interest for students and young lawyers interested in these issues. So perhaps a new development in the practice, or an area that you think is ripe for change, or maybe a problem that you think is overlooked and needs to be addressed. Or a new idea that you think is promising. What can you share with your audience in this regard? Charity, back to you.
Great, thanks. I have so many answers to this question, so I'm going to have to limit myself a little bit. I think maybe I will focus on mandatory human rights due diligence legislation. You know, this is something that I think reflects what I would say is now outside of the United States, perhaps an emerging consensus, is certainly not within the US, but outside of the US, there is this emerging consensus that when companies have business practices that incentivize labor rights abuses, that maybe they should be accountable for that, right? So I think that within the US context, like under the Alien Tort Statute or our other human rights statutes, typically you have to show this like very high level of intent, right? You have to show that they planned to create this particular abuse, when the reality is most labor rights abuses are created by low purchase prices and really short timelines on filling an order and really problematic power dynamics within these supply chains. And so how can we shift the burden there so that it's a little bit more of a strict liability concept, so that the companies see the way that the behaviors that they're engaged in are resulting in abuses, and then they change those behaviors downstream so that the abuses might not occur. They create environments that are safer for workers. So I think mandatory human rights due diligence legislation, which has now been passed in various forms in the Netherlands and in France, is kind of the one that's most touted because it has a little bit more access to remedy within it. I think that type of legislation that shifts that burden is really important and is reflective of, I think, sort of ideas or ways of thinking about the way supply chains operate that have been prevalent in the labor sector, but like in human rights and more mainstream have not really been prevalent. And so it's kind of mainstreaming and giving some legislation to back those kinds of theories. Hopefully, over time, the US might move in that direction as well. I think that this isn't a perfect model. So the question, does it deter the behavior? Yeah, probably. It might change corporate behavior, but what about once the harm has occurred? Is there still a possibility for a harmed worker to bring a case and get actual remedy for that under these laws? It really varies, and I'm not sure how that's going to play out going into the future as a trend. But I do think that it's really exciting. And it also kind of reflects, there's something that was developed over the last few years called the Worker-Driven Social Responsibility Network. And that's something that takes the idea of corporate social responsibility, which has largely been public relations, and very rarely has real impact for workers or for the entirety of a workforce of a company. They'll more often do very limited interventions and then publicize those, even though the vast majority of the workers are not benefited. A worker-driven social responsibility model looks more at it from a worker perspective and is much more comprehensive. And I think they're bringing in modes of analysis that we're now seeing kind of trickling up to decision makers. So I think those are to me, that's the most exciting development in the field. It's almost more theoretical, but it does have some real impact in those legislations.
Wonderful, thank you. Let me now move to Josh.
Thank you very much. I would say for me, there's a couple that come to mind. One, both having to do with the nexus between labor rights, labor issues, and our trade programs, and both related in some way to the USMCA. So one is facility-specific enforcement of labor rights under trade agreements. So or trade programs generally, we in the past and actually still currently, including in USMCA, the model is a state-to-state enforcement tool, and there are certain criteria that must be met to bring a case. There's depending on the model, manner affecting trade between the countries. Things must be sustained or recurring. There's a number of other pieces to that, and in practice, it can make both the information gathering that's required to file a case and the enforcement of that case challenging. So in the USMCA model, we have it's called a few different things depending on who's talking about it, but I'll call it the rapid response mechanism. So it's essentially a facility-specific enforcement tool. The United States and Mexico have agreed to it, and then Canada and Mexico have agreed to a very, very similar model. It focuses specifically on freedom of association and collective bargaining. And I think, again, it's facility specific. So we're looking at denial of rights in a particular location, a particular factory, mine, facility, what have you. So that's a new model, and I think is getting a lot of interest, broadly speaking, in many quarters, and is a big step forward in how these the labor provisions and free trade agreements can be enforced. There's also a rule of origin, automobile rule of origin provision in USMCA that focuses specifically on wages. That could present a new tool for focusing on those issues. And then as not in the USMCA context, but as Charity mentioned earlier, Section 307 of the Tariff Act has provisions that prohibit the importation of goods made by forced labor. And those, for the most part, have been applied on a specific facility-specific basis, and so allow for blocking imports that the U.S. government believes are made by forced labor. So the facility-specific enforcement, to me, is a really exciting kind of new page in this book. And the other is expansion of the rights and the issues covered. So USMCA goes beyond what we've had in any prior free trade agreement. It focuses on all the core labor standards that many folks on this call, and Colin in particular, know very, very well. But it also includes a prohibition on forced labor and collaboration with other countries on addressing issues of forced labor. It includes violence against workers, migrant worker rights, and specifically expands the definition of workplace discrimination to talk about things like sexual orientation and gender identity. So I think both from an enforcement standpoint and from kind of a normative standpoint of the rights that are covered, we're seeing a lot of advances in this space.
Great, thank you, Josh. I should mention that in this model of international and transnational labor law that we're having this week, we had a webinar on the USMCA and the new labor regime that it introduced, in which a lot of these different components that Josh was mentioning were also discussed. So if you're interested in this topic, you can go and check the recording of that webinar, which will be available on our website as a background of the discussion that we're having here today as well. All right, let me turn to you, Colin.
Thank you. I'm going to connect to both what Josh and Charity had to say in terms of the topics, and then I'll say something about where the ILO is on these things, which is a rather different question. I agree with Charity that efforts to address how global supply chains function and the effects that sourcing through global supply chains can have in some countries is really the big challenge. It's not necessarily particularly new because supply chains have been exploding and moving across borders since the fall of the wall and the creation of the World Trade Organization. It's been a difficult topic for this organization and this office to deal with. We had a conference discussion on it in 2016. One of the consequences of which was that we had a sort of high-level tripartite meeting in February this year trying to address the question of supply chains, and despite our best efforts, we managed to come away from that meeting with no consensus among the constituents. So this is an indication of the fact that this is a political organisation, it's a tripartite organisation. There are many other things that might be said about how we got to where we are on that, but the workers of the world are firmly behind the idea that there needs to be an international standard on responsible business conduct, and that would implement the human rights due diligence model of which Charity spoke. Charity also adverted to the fact that the national laws that are in place, like the French devoir de vigilance and so on, that model has been evolving and it has good and bad effects, but it's moving on. There is a consensus around this to some extent emerging, and indeed, to the extent that there are weaknesses in that, there's a process going on in the United Nations to attempt to establish a treaty around this, which would actually put some binding obligations to do this stuff, not just at the national level, like in the Dutch or the French or the English or the California laws, but at a global level. Now, whether that's going to be possible is anybody's guess. And whether the ILO is going to be able to move forward towards some kind of international labour standard on this topic is literally a very open and difficult question. But the office, we had this meeting in February. We were supposed to be having a discussion of our governing body now, but it's been deferred till March next year. We'll see what kind of instructions we get out of the governing body on how to move forward in that space. It poses enormous challenges for basically the traditional model of public international law, because we adopt international standards, member states ratify them, and then it's up to them to do things at the national level. So by definition, if things are happening in more than one jurisdiction, it can be difficult to deal with that. But it's also true, as the employers insist, that not all supply chains are the same. The balance of power is not the same. It depends upon the commodity, it depends upon the market, and a whole bunch of other stuff besides. One of the challenges I'd say also in terms of global supply chains is, I think, going forward, this tension we're going to see, given what's happened with the COVID pandemic and the impact on the global economy, that in places like Bangladesh and India, there was a report in the New York Times some months ago about possibly 20 years worth of poverty alleviation being wiped out because of supply chains shutting down and production shutting down. So some jurisdictions are going to want to see the model of global supply chains pre-COVID getting going as quickly as they possibly can, I would have thought. Other jurisdictions are going to want to examine things like security of their medical supplies and things like that, which have been called into question because of the global supply chain model. So that's going to add another gloss to the whole issue of how we move forward there. So connecting then to Josh's point about expanding the rights that are pursued through the trade labour linkages, not really on the trade labour link so directly, but more generally, there is a big discussion coming in the ILO about what is the content of fundamental principle and rights at work as they are understood by the ILO. There's a 1998 declaration on the topic, which leaves out things, including some things which are in the US GSP legislation from years back, much less what's been done more recently. But there is a possibility that the organisation will move forward to add occupational safety and health to the concept of fundamental principles and rights at work. Now, if that were to happen, that would be a really significant development, connecting back to what Charity had to say about what it is that companies are going to do, because big multinational enterprises, they have codes of conduct, they participate in corporate social responsibility initiatives, and a lot of those incorporate core ILO standards and the 98 Declaration. So if the declaration is expanded to include OSH, that's got a potentially huge impact, never mind what the organisation, the office might be able to do. So those are some of the things that I think are coming. And the last point I would make is that whilst the ILO is the last place to look for innovation, I would have thought, we are trying to do some interesting things around use of technology, how to get to workers, how to equip them, how to make them capable of understanding their rights and implementing their rights and so on through, for example, chatbots and other bits and pieces like that. And I think that we've all used to learn technology. Here we all are talking to each other through computers and so on. I think that's something we really need to do across the world, because states just don't have the capacity to bring, for example, courts to everybody or dispute resolution institutions to everybody. So if you can do things and capacitate workers in that way, and to address the challenges of organising when we don't have mass production so much anymore, then that's going to be something that needs to be done. Thank you.
Thank you, Colin. Let me now turn to Daniel.
Thanks. I have to agree with Josh about the fact that the main development that we have seen right now is coming from the renegotiation of NAFTA, and the rapid response mechanism is something that might pose a lot of challenges for the field. And I would like just to highlight a couple of them, because, well, just to state the premise is that the lack of sound labor institutions and the existence of low wages in developing countries is one of the main reasons why blue-collar workers have been suffering by trade liberalization. And the idea is that if you strengthen these labor rights and guarantees in developing countries, this will level the playing field of international competition and will improve the conditions of workers on developed nations. So I believe that there is reason to think that the conditions of workers in Mexico can be improved by the labor institutions that have been agreeing on USMCA and the labor reform that has been handled. But the extent to which this improvement will resonate on the conditions of workers in the US, I think that has to be seen. And that it will be the first challenge, is something that people will need to be looking at. There are certain issues about the rapid response mechanism that might also prove challenging inside of Mexico, and is that we are seeing certain threats that even unions within Mexico are planning to use the rapid response mechanism to solve disputes between them. And certain unions that traditionally you will assume that are unions that are protection unions or like pro-establishment unions are accusing independent unions of violating the commitments and saying that they will use USMCA to prove this. And if the mechanism starts to be used in these ways, it might lose its purpose. Another challenge that I see related to this development and the increase of ties between international trade and labor law is that it's important to use economic international agreements to enhance the conditions of workers in developing countries. I think that this is an important tool, but there's a balance that must be struck as whether there is actually an improvement of the conditions and improvement of institutions in developing countries, but that we don't go to depriving developing countries from the opportunity to seize their comparative advantages. And the fact is that for a lot of developing countries, having a low-wage workforce has been a competitive advantage that has allowed them to catch up and increase their productivity. And then the increase of productivity will lead to higher wages. So there is a balance that must be achieved in this way. And the final challenge that I think that has to be resolved is which is the forum for these discussions. These discussions have to be developed through bilateral deals that, like the USMCA, or is there certain appetite to move this discussion to the WTO? The WTO is under a lot of stress right now, but there's people that say that, okay, why don't discuss labor again on the WTO?
Thank you, Daniel. I have just a quick follow-up for clarification, if you don't mind. How would the rapid response unit mechanism be used or could be used in the form that you suggested by different labor unions in Mexico? So the idea would be that they would collaborate with unions in the United States that would then raise this question or ask their own government for a panel, or how do you see this operating in practice?
I think that could operate in different ways. Right now, it could be like unions looking for allies on this side of the border to raise cases, but you could also use the hotline that has been implemented through the agreement. And it's also a rhetorical tool. It's a tool that unions have been using to say you are violating. And pretty much like everyone right now in Mexico is saying like whatever the counterpart is doing is violating USMCA or is inconsistent with USMCA. So I think that, and specifically if there are two unions that are disputing the titularity of collective bargaining contract, they might say that the other union won it just because they were like using certain techniques that are not in accordance with the spirit of USMCA.
All right, thank you. So let me now move to the third question. And so we're gonna change gears a little bit. Now we have a really sort of great set of questions you put on the table of challenges that you see in the work that you're doing in the field, in the specific field that you're working on. And this gives the participants a good idea of exciting themes that they can be focusing on. Now I want to ask you a different question, which is basically to share a bit of your trajectory. So we're gonna move to you sharing your experience and how did you land where you are, and also what lessons or insights have you gathered along the way that you'd like to share with our audience today? So let me move to you, Charity.
It's unfair that I always go first, so I don't get to comment on all the interesting things everyone else says, but it's fine. It's fine, I'll deal with it. Okay, my trajectory is probably a little bit unusual. I will admit at the outset. So, you know, I really got started in this field as a student anti-sweatshop activist in my undergrad. That was, you know, it was the late 90s, early 2000s, which was the height of the anti-sweatshop movement. So it was an exciting time to be involved in that. It was sort of like a boot camp for global supply chains. And we also, I think, got to get, you know, a lot of direct exposure to workers. We, you know, we're thinking about the way that pressure works within these sort of buying relationships as we were pressuring universities to change their buying relationships. I know that Georgetown had a really active group. And in fact, I think that Georgetown's bookstore still sells some products that are made in factories that were sort of influenced by that process. So after that, let's see, in the early 2000s, I was also really involved in the School of the Americas Watch movement. I got arrested at the School of the Americas, spent 6 months in federal prison for civil disobedience. And while I was there, I had to work at a factory for 12 cents an hour, and I separated scrap metal, worked in a pole barn with a magnet separating aluminum from steel. I drove a forklift. You know, I think that gave me some insight into kind of forced labor. I realized that if it's for punishment of a crime in the United States, that it's fine. But generally, I think that prison labor around the world is often considered a form of forced labor. But so just sort of seeing the way that dynamic works and how it incentivizes a lot of abusive behaviors by, in my case, guards, but in other cases, managers, et cetera, really gave me, you know, a lot of inspiration in this area. After that, I started working at a little nonprofit here in Chicago called the U.S. Labor Education in the Americas Project. And I did worker like organizing support and monitoring on plantations in Latin America. So it was mostly flour and bananas and coffee. We did some anti-union violence investigations, did some work around the Jeff Vogt, who was on your panel. You know, so that also, I think this all being pre-law school kind of work gave me a lot of direct exposure to workers and thinking about what are the most effective or strategic interventions in supply chains to change these conditions. So thinking of it really from an impact approach. If I'm working with a group of flour workers in the Sabana de Bogota, trying to figure out how they're going to get Dole, who owns or buys from their plantations, to change practices. From that perspective, how do we change practices? So I think I've always come at it from there. So I went to law school because I saw that a lot of our strategies were not working. We were doing consumer campaigns. We were trying to pressure companies to change policies at the margins, and it was just never having the impact on the actual workers that we were working with. So when I started to see these alien tort statute cases, I thought, that's the thing. This is what's going to make the difference. So, you know, joke's on me. But I think that it was really inspiring at the time to see something that seemed like it could, you know, really make companies change their behavior. So before law school, then about a year before, I started working in the banana zone in Colombia and Magdalena with widows of banana workers mostly. These were plaintiffs in the case against Chiquita. So I was doing interrogatories and things with them in a sort of paralegal capacity for a while before starting law school. And then when I graduated, I started working for that same group of lawyers working on these same cases. So against Chiquita and Drummond, a lot of US companies that had either financed illegal armed groups, had targeted union leaders, but because the Alien Tort Statute only gave us jurisdiction over a very limited set of claims like torture and extrajudicial killing and genocide and crimes against humanity, it meant that the more run-of-the-mill, although still very egregious labor rights claims could not be adjudicated under that statute. So I think that, you know, that was it was hard because shortly after I graduated, the Supreme Court had, you know, ruled in Kiobel that there was no extraterritorial application of the Alien Tort Statute. So most of my years as a litigator were watching, sort of litigating our cases as they died. So that was like a sort of painful way to sort of conclude my law school, this big decision to find a more strategic way to intervene in these supply chains. So, you know, after all of that, I thought, you know, being a litigator probably isn't the most effective way to do this if we don't have statutes on the books that let us do this. And so I really founded Cal to start to really open up that space. One sort of funny thing, and then I will be done because I think I'm at my 3 minutes, but a funny thing is when I was sort of in between those two careers as a litigator and starting Cal, I was like, I don't know, maybe I want to think about how, you know, trade agreement labor chapters are enforced. And so I applied for a job that Josh was a part of the interview team for. And I'm trying to remember what happened, but I think that it was like, this was the last thing I did before starting Cal, is I think that I had a call with you or something to think about the next step in the process. And I withdrew myself from the process and I said, nope, I'm starting this organization. So it's nice to see you here, Josh, but I think that was the last time we really spoke. So I'll pass it to the next.
So wonderful. Thank you, Charity. So Josh, back to you.
That's a great segue. I will just say I remember it too. And for the record, this was at Department of Labor at the time. We offered you a job, so that you left that part out. And speaking of having a tough follow, I don't know how I follow that, but I would say I've always had like a general interest in human rights issues, and I was living in San Diego, and kind of the two human rights issues that were on my radar, this is maybe like 15, 20 years ago, that were on my radar were immigration. And then because I was in San Diego, right across the border in Tijuana, there's obviously a number of maquilas. And so I started volunteering with a group that was working in Tijuana on worker rights issues, trying to help support independent unions. I found the work really interesting. And so kind of always kept a general interest in it. Fast forward a bit, I too was very interested in the Alien Tort Statute, not in as direct a context as what Charity described, but more from an academic standpoint. I just always have felt like there is a lot of value in human rights focused reports that are, for lack of a better term, naming and shaming. But I've always been more interested in something that had some sort of teeth, some sort of direct connection to, if not enforcement mechanisms, at least getting people's attention at the most senior levels that we could. So I practiced after law school for a few years in various capacities. I was a public defender, a couple other things. Ended up deciding, based on kind of my interest in the nexus between labor rights / human rights at the time and international economic and trade issues, I would get an LLM from Georgetown. So I did that. I think I was part of the IBEL program, International Business and Economic Law. I'm not sure that I actually checked every box I was supposed to graduate with that certification, but I was around there and I did graduate. And while I was at Georgetown, I was looking for I guess externship would be the right term, and saw a listing for the Department of Labor's Office of Trade and Labor Affairs, which is part of the Bureau of International Labor Affairs at Department of Labor, U.S. Department of Labor. And it was, I didn't even know such a thing existed. It was talking about trade agreements, international economic law, workers' rights, freedom of association. So I applied, I got the externship. And while I was there, I was still in Georgetown, of course. I applied and was accepted into a program called the Presidential Management Fellowship. That is, I think still exists, but basically creates an opportunity to be hired in the federal government in kind of a separate track from the normal HR process. So rather than just applying to something online, I went through a program and got to meet directly with hiring committees. It's one of the kind of accepted ways. There's a few of them for getting into the federal government. So after a number of years at DOL, worked my way up through management, I ended up at USTR. So I left out some of the more nonlinear parts. I think we probably all think we have a nonlinear path. I certainly do, but I think for me it was the general interest in labor rights and international human rights issues was always there.
Great, thanks, Josh. Let me turn to Colin.
In view of my advanced age, can I have 4 minutes?
Of course.
All right, so my trajectory is by definition different because although born in the US, I grew up in Australia, where law is, for the most part, still an undergraduate degree. So I did law as an undergraduate along with an arts degree. And by the end of that 5 years, well, 6 by the time you count a year off, I'd figured out that the only two things I was interested in were employment and labour law and international law. So what to do with that? I practiced law in various guises in Australia for 5 years. I worked in a firm. I was a judge's clerk. I practiced as an independent advocate, as a barrister, as they say. I prosecuted OSH crimes for a year. And then I went and started, I did an LLM in the US at this law school, which is not Georgetown, but is, anyway, this other law school I went to. And I mean, I'll say more about this in response to the next question, but I did some stuff that was labour focused there. I wrote a paper on the application of the US GSP actually and did research in the USTR files there in the 17th Street, I think it is, Josh, yeah. And then graduated from this other law school and then landed up in DC as an intern in the Washington office, of all things. So then I sort of skulked around DC basically for about 2 years trying to get a job. I didn't want to practice law. I didn't want to take bar exams and go into a law firm because I figured I could go back to Australia and practice law if practicing law is what I wanted to do. So I did that, and basically by the good grace of a former professor I had at this other law school, I managed to get introductions and do some consulting gigs. Did some for, well, what is now the Solidarity Centre on codes of conduct. I did some for USDOL, particularly on, now what's the order of events here? I'm trying to remember. I think that's where I started. That's the first time I did something on Burma. So now Myanmar. So there was a report done on labour practices in Burma, which was commissioned, good Lord, 1997, something like that. So I was the main consultant working on that report. Then as a result of that, I got engaged. I actually worked as the advocate for the international trade union movement in the Commission of Inquiry at the ILO here about forced labour in Burma. And then I connected with, I suspect, somebody that we have in common, Charity, Terry Collingsworth, and I worked on the Unical litigation at a little on-profit in DC, which then went by the name International Labour Rights Education and Research Fund, and has changed its name over the years, but still exists. And then one day I came home, and on my voicemail of my not portable phone, because this is how far back it was, somebody was offering me a short-term contract at the ILO, and I still to this date don't exactly know how they got my name, because this is more or less at the beginning of the internet. Anyway, and if they wouldn't have found me. So I came to Geneva, and I spent about 18 months here in Geneva in headquarters. And then I took a job as a professor in a law school back in Australia, the law school I'd attended. And I did that for 8.5 years, during which time I started doing consulting work for the ILO, because this is one of these things where once you start to know people, you know people. And so then I got interested in coming back to work for the ILO, but I wanted to go and run a project. Running a project didn't become available. A job in headquarters became available. So I took the job for 2 years, and I'm just about to finish my 12th. And I think I'm probably going to be here for a while to come, because the job market ain't that good for old white guys like me just at the moment.
Thanks, Colin. Okay, let me now turn to Daniel.
Thanks, Alvaro. I studied law and political science in Colombia, and their law is also an undergraduate degree. So it took me like 6 years to study both careers, both fields, I would say. And then I participated in an international moot court on WTO law, and this was basically because I was interested in legal theory and international and political theory, and I want to see how supranational regulation could affect sovereignty, and that was my introduction to international trade. I loved it, and ever since I got caught up in the world of international trade. When I finished law school, I went to the Ministry of Trade, and I worked briefly there. And then I started working as an associate in a boutique firm in Colombia that is specialized in international trade and competition law. I worked there for some years, and it was basically anti-dumping, subsidies. We looked at how certain conditions of the FTA that Colombia has with the US or with Canada were being implemented. WTO agreements, how they affected policies in Colombia. But then I said that I want to do something that had like a broader impact. I want to go a little bit more into policy. And I decided that the perfect way to try to do that was doing some more postgraduate studies. And I did a master's in international economic policy at Sciences Po. While I was there during my second semester, I interned at the OECD in the investment division. That gave me a little bit of a notion of how international organizations work and a little bit of a notion of capital markets regulation. And then I came to DC last year to start my LLM at Georgetown. I was also around the IVEL program. I didn't take all the courses because I refused to take corporations again. For me, once was enough. So I graduated from Georgetown this May, and I got involved with Public Citizen. I got a fellowship, and then there was an opening for the director position, the research director position at Global Trade Watch. And I was lucky enough to be in the right place at the right moment.
Great, thank you, Daniel. So we're gonna move to our fourth and final question. I suggest that I'm gonna reshuffle the order in which you'll speak a bit at Charity's suggestion. This is just so you can see how effective she is in making changes. So the question here is, What advice would you offer a recent graduate interested in this practice area? And let me start with you, Colin.
Get out of town, get lucky, speak a language other than English. Right. Or if you're going to do it in a more scientific way, because this is why I mentioned earlier on that the things that happened to me happened in the mid-90s, which was really the beginning of the internet, right? So I had this wild idea that if I left Australia and studied at this other law school, I might somehow be able to get connected to the ILO. And that was not based on doing lots of research on the internet or anything remotely scientific. It was just a wild idea. And to this day, I don't really know how it came to pass, but that is actually exactly what came to pass. And well, serve me right, here I am 12 years in at the ILO again. There are more seriously, there are certain places which are kind of centres for transnational international labour law. DC is definitely one of them. Whether from an academic perspective or a government institution perspective, you've got USTR, you've got USDOL. There's a couple of people who do it at the Department of State as well, right? You've also obviously got the institutions there. You've got an ITUC office there. You've got the Solidarity Centre there, et cetera, et cetera. So there's a real concentration in some places. Brussels is another centre because of the international trade union movement. Geneva obviously is a centre, and so on and so forth. Now, whether it's best to try and get into the field by being in one of the centres is an open question, I think. I think that what is really incredibly valuable is, well, all things are valuable. Research work is valuable, publication work is valuable, and so on and so forth. But I would have thought that activist work is particularly valuable, and especially activist work, which includes having spent some time on the ground in the places where the things that we're trying to address are actually going on. So like Charity's experience of being in Colombia and so on and so forth. And it's one of those things, once you get going, as in any career trajectory, you tend to sort of begin to build the CV, which enables you to get on and take the next step in your career if things go well.
Wonderful. Thank you, Colin. Let me now turn to Josh.
I agree with everything Colin just said, but I think just to flesh out a couple of those that are particularly, resonate particularly well with me, I would say, don't be afraid to take chances. I think, everyone's at different places when they're graduating school, and so each person does their own assessment of their risk tolerance. But I think the people who are able to do things like going to a place where they might have a particular interest, be it a foreign country or another city within their own country, building up skills that maybe are relevant to the field. I mean, you heard Colin mention it there, and I would reiterate, I wouldn't have gotten that first externship if I didn't speak Spanish. So I think, things like subject matter knowledge, on the ground knowledge in a particular context, foreign language skills are just really helpful tools to have. And some people have an aptitude for that and can pick those things up along the way, and some people have to get outside their comfort zone. So I would say, don't be afraid to take chances, learning about your field, understanding your strengths and weaknesses, and trying to, accentuate your strengths and build on your weaknesses. Probably not supposed to say this on a law school, Georgetown law event, but I would say particularly in a place like DC, don't think only in legal. Don't look only at legal jobs, look at policy jobs too. I think that there's, when I look around my work context, there's obviously lots of people like in our Office of the General Counsel who are still practicing as attorneys, but there's a lot of people who went to law school, in many cases really good law schools, and have decided to pursue more of a policy route. So I would say, that's an option just to keep on folks' radars too. Nothing wrong with starting in the legal field. But I personally can't think of anyone who started, let me rephrase that. There's many people I know who started in the general counsel's office or a solicitor's office in the government who moved to more policy work. So I think, that can be an incremental process, or you can go directly there, but I think expanding your search in that way is always helpful. And then the last thing is, there's no one path. I mean, that's obvious just from this conversation today. And I'm sure folks know that already, but I think, whatever iterative process you go through to get where you ultimately want to be is the right path for you. I always think about it like, you get to pick your kind of general path of your interests and your aptitudes. And then, as Colin said, you just kind of get lucky. Opportunities come along and you take advantage of them or you don't. But I think sometimes folks will focus on a specific organization or a specific job. And, you know, if they're Colin, it works out and they get that job at the ILO. But I think for a lot of people, you know, we just need to be willing to adapt within that broader path and react to the specific opportunities that arise.
Wonderful. Thank you, Josh. Let me turn to Daniel.
Well, speaking of my experience, I will just mention two things. Is first, it's probably not a good idea to label a field of law as irrelevant to you. I remember when I was in law school, I was very interested in international trade, international law, and I thought, okay, administrative law is not that important to me, and I didn't pay a lot of attention during those courses. And the first thing that I had to do when I got into the law firm was drafting a lawsuit against the Colombian Customs Authority. It's like, okay, how I'm supposed to do this if I don't know a lot about administrative law? So the law is very interconnected, and it's important to understand understand a little bit of everything and also understand the connections. It happens, it's the same thing for me for labor law. I didn't think that I was going to be involved in labor law for a long time, and I did pay attention to my courses in labor law, but then now I am in this panel. I think that this is something that is important. And the other advice that I will give is that it's important to diversify your toolkit. For me, going to Sciences Po and getting some economic policy knowledge and getting quantitative skills helped me a lot to go into the policy area that I want to go. And specifically, if you are thinking of your career a little bit more broadly, like Josh was mentioning, like thinking about policy jobs, I think that having quantitative skills is something that will set you apart, because then you have two things. You have the legal skills and the quantitative side, and that is something that is helpful to get into these kind of positions.
Great. Now, finally, Charity.
I just want to say it's so much better to go last. So I think that I absolutely agree with everything that was said. I think that Colin said exactly what I was going to say, so I'm going to change what I'm going to say. So I think that in addition to everything that was just said, which is 100% on point, and especially the language piece, I wasn't going to say that, but I'll tell you what, if I wasn't bilingual, I wouldn't have gotten into my first, pre-law school international labor rights job. So that is really kind of a important gate that people should recognize and really invest in those skills now. Like, I think folks are really worried about their legal writing skills. Everybody can learn that stuff for the most part, right? But there's a lot of other skills that I think we ignore that are maybe more important. Similarly, I think that sometimes in law school, there is like I don't know, there's a culture where folks can be a little, they want to make sure that their resume is super diverse. I want to show I'm interested in everything. I have experience with everything, instead of showing that they're really passionate about one thing and leaning in. And I think that, especially like Josh and Colin both kind of emphasized they had this interest early and then really pushed in that direction. So just like identify your passion and focus there. And then as one other thing, I think that thinking about, this is probably true of any career, but is in some ways maybe underemphasized in a law firm style environment. But really thinking of yourself as a whole person. To what extent are you able to go in and not just exhibit kind of leadership and technical ability, but like kindness and patience with yourself and others. Some of those things, which I think play out well in some direct services environments where you'll see, employers looking for your ability to work with, someone coming into your legal clinic. I think that really plays out in every single environment. So if you can demonstrate that you are a kind, good person who's a team player and has a lot of patience, then I think that you're going to do a lot better than by emphasizing your technical skills and the diversity of your resume.
Great, excellent. So let me now open up for questions from the audience. And what I would ask our participants is to turn on your videos And also say your name, identify your affiliation, and then formulate a question for a specific panelist or just a general question to whomever wants to answer. So let's open it up. And you can, there's a function where you can raise your hand. And so if you do that, I'll be able to see it and then just call on you. And if you can't see that function, then just unmute. Okay, great, I see. Sergio, go ahead.
Good afternoon to everyone. My name is Sergio Gomez Lora. I am the CEO of the Business Council of Mexico. We have an office in DC, and we have been here for over a year. And as you might imagine, we have been following very closely the USMCA. So first of all, let me, Alvaro, congratulate you and all the panelists for a very candid discussion. I appreciate it very much. Today, as you are, I will not be speaking on behalf of the Mexican Business Council, but on my sharing my personal views. And I have a brief comment and a question, and the question is for Josh. And thanks a lot, Josh, for your comments. I appreciate it very much. The comment is that you mentioned one of the objectives of these tools, trade and labor related, and this rapid response mechanism is to create awareness. And in that sense, let me tell you that the USMCA labor provisions, the rapid response and the whole package has fulfilled that objective. It has raised a lot of awareness. The Mexican private sector is working very strongly, not only because of the USMCA, to be honest, but obviously because of the labor reform is there and is law in Mexico. But to be very candid also, the USMCA has really raised awareness in the business community, in the export-oriented community, and Mexican business organizations are engaging into a lot of efforts to let the community be aware of the new provisions and to take specific measures to advance. I just give you a couple of examples. One is we put out there a tool that is called the self-evaluation tool, where we are spreading the gospel through all the national associations and to all the companies that are member to those, that they have to use this tool or any other similar tool to make a benchmark or where they are in terms of compliance with the labor reform. So this is a tool that is out there. We have given hundreds of seminars, and this has gone to thousands of companies already. We have feedback, so we know some of them are looking at it and are implementing it. The auto industry, for example, the Auto Part Association is recommending to all its members to use the tool. So this is one example. Other example is we are working very strongly sometimes together with DOL into child labor and into forced labor cases that have been pointed out in the past and are still there. So we are engaging aggressively with the leadership of the agricultural business community into putting a specific action, a couple of pilot projects in a couple of states. So things are moving, and things are moving very fast, which is just 3 months from the agreement that entered into force. But that was my comment, and then my question, Josh, is the following. As you know, there will be cases where the denial of right will not come from a company action, but could come from a union action. I mean, the key players of the reform are the management, the companies, and the unions. And a union action or inaction could generate a denial of right for the workers. So my question is, how have you thought, what do you think, how should the cases where we have unions that have that would prioritize their own political agenda, not the workers' rights agenda, how would that be handled to these mechanisms? Because the only remedy or the only penalty here is for the companies, but the denial of right could be from a union without participation of the company. So how are you imagining that process going on?
Sergio, thank you for the question. Thank you for the comment as well. I'm glad to hear that awareness is being raised. I think one thing I would say in response to both your question and the comment is, it's still a government to government agreement, right? So it has a novel enforcement tool, but it sounds like you're well versed in this, so I'm sure you're aware, but under Annex 31A of the USMCA, when we go through those steps, if we were to initiate that process and bring a case, the initial steps in that process involve engagement with, in this case, the government of Mexico, right? So I think the goal from my standpoint always is if an issue comes up, we look into it, we think there's merit, we think there's a problem, the goal is always fix the problem, right? I mean, the goal is not like, try and win a case. That's one of the tools we have, but the goal is to try and address the problem. So I think, to the extent that problems can, if it's something outside of the scope of a particular company's action, or a particular labor organization's ambit of control, we're always, the initial steps are always government to government. So if we can come to some sort of agreement or some sort of remedy in that context, then that's from our standpoint the best way to do it. The focus is denial of rights. So it's kind of hard to answer a hypothetical without, turning this into a conversation between you and I, where I have a lot of follow-up questions for you. But I would just probably in this context leave it at, if it is a denial of rights that meets the criteria under the rapid response mechanism, we would engage on it. If there's a case there, we'll look into the merits and we'll pursue it if it's meritorious. But the focus really is on the actual denial of rights. So again, it would depend on the specific context there, but I think I'd fall back on the ultimate goal is to remedy the issue. So if we can do that in a bilateral diplomatic way, then that's a great option for us to have.
Thank you.
Thanks. All right. Let me see who wants to go next. So you can raise your hand or just turn your mic on to ask a question. Lelia.
Yes, can you hear me?
We can hear you. We cannot see you, but we can hear you.
Yes, good. I'm having a bit of trouble with my video, but thank you very much, everyone. I would like to go back. Of course, I would like to ask questions to everyone, but with benefit of a short time that we have, I wanted to go back to Charity's comments on the importance of developing your soft skills. So if you could evaluate, develop that a bit more, Charity, from your perspective and all your work and your leadership, why is that important for lawyers in particular?
Yeah, I need to try to not make this into a huge tangent because I have so many thoughts on this. Here's what I will say. I will say that we review hundreds of resumes every year for intern applicants, fellowships. The attorneys that I have in my office are extremely emotionally intelligent. They have great technical skills. They work collaboratively really effectively. They all exhibit a lot of leadership. And part of that is on their own skills development, and then also part of it's on us, right? I think that what we see, my own experience and Colin, you're right, with Terry Collingsworth, his sort of manifestation as IR advocates, international rights advocates, was a subgroup of a law firm. We were sort of a department, but we were very separate. But so then increasingly over time, the law firm sort of consumed us, and we got to really get a sense of typical law firm culture. And I will say that they don't value a lot of emotional intelligence. And in fact, if you are responding in really thoughtful ways to, pushback from firm partners, that's usually not welcomed. And so I think that there is a question of, do all legal environments really value this? Or do some legal environments value this? I would say that what I hope is that the generation that's coming into legal environments is not going to tolerate some of the types of hierarchies and abusive behaviors that occur within law firm environments right now. And so if it doesn't change from the top down, I would hope it changes from the top up. So I would say that like this whole person kind of attitude, it's partially just, you know, law school is teaching us to be perfectionists and to be highly anxious and very punishing to ourselves. And so when I get all of these intern applicants and I interview them, you know, they're so nervous and some of them are sweating and it's this really painful experience. Whereas if they were being a little bit more patient with themselves and kind to themselves, I think that they would perform better in an interview. They would perform better in an office environment. And so we both try to encourage students to start cultivating that now because it'll help them get in, but also employers to cultivate that because it really is a little bit pushing upstream. There is a problematic culture in our field that I think we need to push back against. I don't know if that's a full answer to your question, but I think it's both ways. It's not just that students need to develop, it's that we need to develop some of those skills and expectations.
Yes, it does. Thank you so much. I actually had the pleasure of working with some of your colleagues as part of different multi-stakeholder platforms, and I saw how they conduct themselves at the meetings, but also how mindful they are, no? So I think what you are talking about is central to the role of lawyers as leaders, no? And thank you so much for all your work.
Thank you. And yes, I have to say in all the career path sessions that we've had so far, which are 3, this hadn't really come up as an important point of focus. And so I'm glad that you're raising it. I think it's an important theme to think about, not only for employers, but also I think for us professors in the basically training of new lawyers and in the interaction with students in law school. So I think that's a really great point. And I mean, let me just follow up on that question because of course what you did was you created your own organization. So that's a great way to ensure that the work environment is going to be, you know, the work environment that's conducive to that kind of interaction. Not that it's easy to create a new organization, and obviously, no, it's not. But what would you say to lawyers, to recent graduates, or even students who are entering organizations where they're really the entry-level position, they don't have much power over those dynamics and interactions? What would be a good, useful strategy for those students and young graduates who are entering law firms, government, you know, NGOs that might exhibit this kind of hierarchies, or simply just focus and attention to the kind of skills and technical skills that you think are important but are just part of the toolkit of lawyers?
Yeah, I would say 2 things. So one is that if you're working in a team that's a part of a bigger structure, you have a lot more influence on your specific team than you do on that bigger structure, right? So if over time you can express it in terms of needs, hey, you know, I could do my job a lot better if I understood a little bit more about what else was happening here, to try to discourage your supervisor from giving you a set of narrow tasks so that you can never see the big picture. There's all these small things that I think we do as supervisors that undermine the ability of our staff to exercise more leadership and to feel really included within the team. So thinking about ways you can express it in terms of your needs that might shape the way that your small group is operating, they could have effects more broadly. I think the other thing that we have really discovered and worked on and experimented with at Cal is in our sort of design thinking process. Design thinking focuses on what they call the user, because it's sort of, the language is much more for-profit and tech-oriented, but for us, that would be like the worker, right? So a user-oriented perspective where you're always trying to figure out who's the benefit going to, right? How are we identifying what the benefit is, who it's going to, and how are we making sure that from that person's perspective, it's accessible? Sort of shifting the way that we think of things instead of more trickle down to more bottom up means that the way that we design our strategies can be much more innovative and effective. And so if a young attorney is coming in and is saying, can we shift our framework? You'll find that over time, by being able to propose more flexible, creative ways to approach the problems that have been, you know, done in the same way for many, many years, that value will be recognized, and that kind of gives you a little bit more leadership within a team, and from there you have more cultural influence. So I realize that is, you know, it's hard to do, and there are some environments in which it's just not going to happen, right? And I think that's the other piece. So just like you don't go and knock doors, you're not going to go knock doors of Republicans and try to get them to vote for Biden. You also are not going to go into a really problematic hierarchy with very misogynist firm partners and try to convince them to change overnight. You might not choose that firm. You might say, well, it's all, white men in the firm leadership and they have this kind of culture and they're notorious for it. Okay, so make it harder for them to attract highly qualified staff and young attorneys. So I think that's another piece of it.
Wonderful, thank you. Let me see if there are other questions from our participants. Okay, so apparently none. So let me ask our speakers if you have questions for your fellow speakers, or there's something you'd like to add to the conversation that we've been having. I have a couple of other questions, but I'd like to give you a chance if you want to jump in.
Can I ask one for Josh?
Yes.
Okay, so Josh, one thing that we've been thinking about, so we worked on the Section 307 petition, and as we mentioned, this is part of the Tariff Act. We worked on the petition related to the cocoa industry that was filed in February, and then we worked with Jeff Vogt and a bunch of others on one related to ginseng cotton in, when was that, August. And there's others, there's sort of a community of people thinking about this as this emerging tool. So to what extent do you think that there is a possibility to frame a request for remedy differently than just asking for a withhold release order? So typically for people who are listening under 307, the remedy is you stop the goods at the border. They're produced with trafficked labor, forced labor, stop the goods at the border, or, I mean, that's sort of but that's a general concept, right, of blocking the goods, although that's a bit of a process to get to that actual point. But if you instead created like a 6-month grace period where you said, hey, CBP, why don't you say that I will block these goods in 6 months, or I'll issue a WRO more specifically in 6 months, if you do not take all of these steps that are what's contributing to the environment that's causing the forced labor, whether that means stop, reimburse recruitment fees or give all the passports back to the migrant workers, whatever it might be, so that you could create impacts of a 307 petition that would actually help the affected workers rather than just sort of creating a little bit of disruption in global trade. Do you have thoughts on, CBP has given us different answers on whether or not they think they have the power to do that. And we've seen some actions that they've taken that sort of move in that direction that we've been pretty happy with. So I just didn't know if you had thoughts on that as a viable kind of alternate use of the statute.
I mean, wearing my two hats, which are my personal capacity and not a CBP employee, I would say, my sense is remediation is something that would be incredibly valuable in this context because, hitting a quote bad actor with a stick can be effective if it's a big enough stick. But if you're really focused on integrated supply chains and places that are, you're looking at a particular facility, it can be hard to have the stick that would actually bring about a result. So in theory, I love the idea of remediation. I would have to, CBP would know better their legal parameters on what they can actually do as part of their process. My understanding is they have the WROs, as you mentioned. They also have something that they call a finding, which, you seem to know about and has a bit of a higher legal standard for application. But, my understanding is that they are, doing a bit of a deep dive on what their options are. I mean, I don't know that the WRO is necessarily the best possible tool, and I think CBP would admit that, but I think that they see it as, what they have for now. So my personal view and my personal capacity is that it would be great to have something that allows for some remediation. The challenge, of course, is going to be if with that advance notice, is there going to be, depending on the context we're talking about, could they just reroute it through different importers, through different locations, You know, are you then just giving them a chance to try and change their supply chain practices rather than their labor practices to try and be evasive? So I'm not an expert in any of that, but again, I think like something that would allow for remediation would be most welcome.
Wonderful.
I wanted to ask a question to Colin, and it's basically about how does this work in Geneva, having these two communities, the trade community and the labor community, they interrelate? There is like a forum where they can have discussions, or they are pretty much like two worlds apart?
Yes, the latter. In fact, it's a peculiar thing about working for an international organisation, or at least the one I work for. I never go to meetings at the World Health, I never go to meetings at the UN, I never go to meetings at the World Intellectual Property Organisation or any of these other things that are all headquartered here. I can see the World Health Organisation out my window. I had nothing to do with them. Now, there are some folks in this organisation who have some connections to other organisations, including WTO. There have been joint research studies done, for example. But on the bigger kind of trade, labour, politics, social clause type stuff, I really don't know how that works, to be perfectly honest, unless it works at the very high level where perhaps our Director General engages with it's the Secretary General of the WTO. So, yeah, and of course, as you probably know, ironically, they are in the ILO's original building down by the lake, which has got lots of lovely murals in it and all sorts of stuff. But yeah, not an awful lot, I think, is the short answer.
It will be, I mean, I don't think there's much movement there at the moment, meaning in terms of trying to bring some of what the free trade agreements, both bilateral and regional, have done in terms of incorporating labor standards to the multilateral level at the WTO. But this is a moment of reckoning at the WTO too, particularly in terms of the dispute settlement system. But it seems like it might be maybe an opportune moment to start sort of bringing these ideas and see if something can be done at the multilateral level. I remember when I took my class, I was teaching in London in 2014-15 at Georgetown Center for Transnational Legal Studies. And I brought my class to Geneva for 2 days of meetings with the WTO. And that was incredibly striking, the sort of the realization that the building had been the original ILO building, and that you had these huge murals in these rooms, beautiful murals of industrial work, you know, with all these sort of evocations of the importance of work for prosperity and for human emancipation, whereas while at the same time the issue and the linkage having been completely sort of severed from trade discussions. And so that was a really kind of visual shock, you know, to see the difference in terms of how the building felt and then, you know, what was going on in terms of policy. But so maybe this is also an interesting moment for trying to think about how recent developments in free trade agreements, including the USMCA, might help stimulate new thinking and new models of enforcement at different levels, including perhaps the multilateral. I don't want to be too hopeful about it, but it might be, you know, a good moment to try again. We are unfortunately out of time. I have to say I've really enjoyed this discussion and have enjoyed tremendously seeing all of you and listening to your insights, listening to your trajectories, and also your advice to our participants. So thank you so much for joining us today. I wish you well, and I hope we get to see you in person at some point, not in the too distant future. Thanks a lot.